Hi, I'm Kenny. In last video, I introduced the concept of jurisprudence and its application in Canada immigration. Through a case study, you have now learned that the visa officers must follow two rules when making the decisions. Decisions must be reasonable, and decisions must be based on the law. The latter is one of the core requirements for the duty of procedural fairness. In this video, I'll continue to introduce another two core requirements for the duty of procedural fairness: the right to be heard and the right to fair and impartial decision-making. This is through the study of a humanitarian and compassionate application case. Now let's do it. Many people got to know the procedural fairness by a document named the Procedural Fairness Letter, which is issued before your application is refused. This is often seen for permanent resident applications, some inland temporary resident applications, and citizenship application, as we discussed in last video. So what is a Procedural Fairness Letter, and why it is always issued before the application is refused? This is actually to reflect another requirement for duty of procedural fairness, which is the right to be heard, meaning the applicant must be given an opportunity to address and explain about the officer's concern when the officer believes the application should be refused. In some cases, the officer's concern is addressed and the officer believes the applicant meets both the eligibility and admissibility requirements. The application is approved. But in many cases, the officer's concern stands and the application is refused. This proceeding ensures the applicant's right to be heard, reflecting the procedural fairness of natural justice, but normally is not applicable to outland temporary resident applications, including temporary visitor visa, study permit, and work permit applications. Except in some cases, the refusal is based on some information obtained out of the application package submitted by the applicant. This concept is easy to understand. And now let's talk about another requirement for the duty of procedural fairness: the right to fair and impartial decision-making. Through the study of a very famous landmark case of a humanitarian and compassionate application, let me first brief the happenings in this case. In 1981 August, Mavis Baker, a Jamaican citizen, entered Canada as a visitor. She remained in Canada since then, and worked illegally as a live-in domestic worker for 11 years. She got 4 children born in Canada. The oldest son, Paul Brown, was born in 1985, and then the twins Patricia and Peter Robinson were born in 1989. Followed by the youngest child, Desmond Robinson, born in 1992. Right after that, Baker suffered from postpartum psychosis and was diagnosed with paranoid schizophrenia, so she applied for welfare. At that time, due to her mental illness, 2 of her children were placed in the care of their father, and the other 2 were placed in foster care. Now her condition has improved. The 2 children who were in foster care are now again under her care. In 1992 December, Baker was ordered deported for working illegally and overstays her status. She applied for HNC application in 1993. She submitted documentation including the submission letter from her lawyer and the letters from the doctor and the social worker. The HNC factors she claimed include: although she was still experiencing psychiatric problems, she was making progress. She might become ill again if she were forced to return to Jamaica, because the treatment there might not be available for her. Secondly, she was the sole caregiver for 2 of her Canadian-born children, and the other 2 also depended on her for emotional support and were in regular contact with her. So obviously, if she were deported, all these 4 children who are Canadian citizens would lose the care from their mother. Thirdly, she would also suffer emotional hardship if she were separated from her children. On April 18, 1994, the immigration officer M. Caden refused her application. When Baker requested the officer's notes, there are only notes available from immigration officer G. Lawrence. Let's see what the note says. I don't want to waste your time by reading the entire notes, so I'll just highlight part of it. You can see here has a total of 8 children. These are all capitalized letters. This case is a catastrophe. It is also an indictment of our system that the client came as a visitor in August 81, was not ordered deported until December 92, and in April 94 is still here. She will, of course, be a tremendous strain on our social welfare system for probably the rest of her life. There are no HNC factors other than her 4 Canadian-born children. Do we let her stay because of that? I am of the opinion that Canada can no longer afford this type of generosity. On May 27, 1994, Baker was served with a direction to report to Pearson Airport on June 17 for removal from Canada. Deportation has been stayed pending the result of this appeal. So this is the appeal for the refusal of a judicial review at the Supreme Court of Canada. The judges analyzed quite a lot of issues in this case, including, of course, was the refusal decision unreasonable? But I will mainly focus on another issue. Was there a reasonable apprehension of bias in the making of this decision? You probably have already noticed the strong emotion reflected in the immigration officer's notes. So many letters are capitalized, and it totally looks like an expression of the officer's personal political opinion towards the system of Canada society, instead of a professional legal analysis of the case itself. As I discussed from last video, decisions must be based on the law. So is there a clause in the LPA or the LPR saying that when determining an HNC application, the burden brought by the applicant on the social welfare system should be considered as a relevant factor? Or is there a case law saying so? I couldn't find such a thing. So obviously this visa officer overrides the law itself with his own political opinion, which constitutes bias towards the applicant. Well, this is my own analysis, and I will put the link of this case down the video so that you can check it out if you are interested in this. The judge's final verdict is, therefore, both because there was a violation of the principles of procedural fairness owing to a reasonable apprehension of bias, and because the exercise of the HNC discretion was unreasonable, I would allow this appeal. Through this case study, I hope you now understand what the right to fair and impartial decision-making means, and you probably learned about the HNC consideration. It is true that you would very likely have sufficient HNC factors if you have those 3 or 4 Canadian-born children when you compare your circumstances with Baker's in this case, and you can probably make a successful HNC application. But I believe many of you wouldn't have such extreme circumstances. Does that mean that you wouldn't make a successful HNC application if you don't have a Canadian-born child at all? Of course not. Don't just rely on the information from this case, because there is another later landmark case about HNC application, in which the 9 judges of Supreme Court of Canada developed a very thorough analysis of the spirit of Canada HNC consideration. I will host another video for that case particularly, so stay tuned. Here I have a tip for you when you read the case study from the court. Do not simply try to compare your circumstances to the person concerned, but try to understand the logic and the reasoning of the judge, because there are no 2 identical cases. Only one single different factor in the cases can make a huge difference on the outcome of the case. So far, you have learned that The boundary for the visa officer to make a decision is the duty of the procedural fairness must be fulfilled, and the decision must be reasonable. Besides these rules of procedural fairness, is there any other requirement for the duty of procedural fairness? The answer is still yes. In next video, I will talk about probably the last rule of procedural fairness that I would do in my videos. I'm Kenny. Learn my lessons on your way to Canada. See you in next video.